been briefed before this court, and it's hard to see that equitable estoppel would...
No, I'm not suggesting that this is a case in which equitable estoppel would excuse noncompliance. I'm just asking whether you have to agree, if you recognize that equitable estoppel might excuse the late filing of removal, that equity might possibly extend further to other comparably egregious situations.
I'm not suggesting that equitable estoppel would apply. I don't think it would apply to this removal statute. And the reason I say that, I just bring it up as it's not something the court has considered. It's a separate question. I don't think it would apply here. And I say that because there is so much, there's so many equitable considerations that are already built into this statute that this court might well decide if estoppel was briefed and before this court that it didn't apply. All
right. Well, thank you. Let me ask you one other question, at least for now, and that is, I would be interested in your response to the arguments that are made by some of the amici about the consequences.
Introducing the score bet
U.S.-Canadian relations if the state court orders that operation of the pipeline be terminated. Those are spelled out in the West Virginia brief. They're pretty severe. And Mr. Bursch made the point that if this proceeds in state court and the state court issues a preliminary injunction against continued operation of the pipeline, it could be a long time before the issue could be, this issue involving treaty rights, which is a federal question, could be reviewed here. So what would you don't really address that, so what would you say to that?
When Congress wants a kind of case or a kind of issue to be decided in federal court, it mandates exclusive jurisdiction. And otherwise, state courts have concurrent jurisdiction. They have reserve power under the Constitution to adjudicate cases in their own courts. This is a state official, state claims filed in a state court. Congress, when they set up the removal process...
So the answer is it's just too bad. And maybe that's the answer. Sometimes the law produces consequences that are not desirable. But what we're told, this is in the West Virginia brief, they're quoting Canadian source, shutting down Line 5 would result in a massive shortage of gas, diesel, and jet fuel in both Ontario and Quebec, not to mention end thousands of Canadian jobs. A special committee of the Canadian Parliament concluded that Line 5 shutdown could reduce safety, create shortages of various energy products on both sides of the border, et cetera, et cetera.
The state's position is that these are state law claims. None of those considerations are at play here because we trust state courts to adjudicate issues, to even federal questions. They've been doing that since the founding, and we trust them to do that with this court's backstop. If something goes really awry in a state court and it's an important matter of federal treaty, it hasn't been given exclusive jurisdiction in the district court, this court can review that and can fix that. But we trust state courts to do their job and to have concurrent jurisdiction. And one of the reasons there has been a tradition of strict enforcement of the removal deadline here is out of respect for state courts. And this court had said over and over in a long line of cases from Babbitt versus Clark on that when the deadline is missed, remand is necessary. And this court has said that strict procedures, the statutory procedures for removal are to be strictly construed.
Counsel, the state court action here has been stayed for most of its existence. We now have a separate federal action. In that case, the district court recently granted summary judgment to Enbridge, finding that the attempt to revoke the easement was preempted by federal law, correct?
Yes.
So if we affirm the Sixth Circuit, that will result in litigation in both state and federal court, correct?
The way that stands now is that there has been an adverse judgment in a federal district court, including rejection.
If we reverse the Sixth Circuit, I misspoke.
Yes.
Then there'd be two actions, a federal and a state.
Yes, the governor has
So
filed.
wouldn't it avoid waste to have these two actions proceed together in the same court?
The Attorney General and the governor has always been concerned about these two, about cases being not on the same track. The Attorney General and
Right,
the
so
governor.
assume you win here. Could you represent, or are you willing to represent, that on remand, you will ask the state court to continue to stay this action until the federal action finishes?
There has already been a stay of.
I've asked you a very different question. If you were to win here, are you willing to commit that you will ask the state court to continue its stay pending resolution of the federal action?
I haven't talked to my client to be able to confirm that, but that's certainly something that we can talk about strategically.
And if the strategic is you want the state court to beat out the federal court, shouldn't we care about that? That was Justice Alito's question.
The Attorney General does care about staying in state court. She believes these are state.
Yeah, but it didn't act very expeditiously in state court.
It would be a strategic decision. At this point, there has been a second stay in order to see what the Sixth Circuit is going to decide. And then
one final question. You give us two grounds to reverse. The one is that this is not a statute of limitations. And the other is that even if it is, the presumption has been overcome. If you were to win, which is the easiest and most narrowest ground to win?
I think the easiest for this court is to say not to deal with the statute of limitations and the presumption issue, because we think that the text and the structure and the history here absolutely mean that congressional intent would say that even if there was a presumption, it would be rebutted.
Is there any way, some of them are clear on how to distinguish them, but Mr. Birch mentioned 4 cases that talk about losing a procedural right to proceed, Lozano was one of them, and there were 3 others that he mentioned. Can you distinguish each of those cases?
I think one of them was Lozano, definitely talked about what is or isn't a statute of limitations. There was no statute of limitations there because there was the opportunity for recovery, albeit adjudicated differently. I believe another one of the cases was Young, and there the court said it was a statute of limitations. It was, albeit a limited one, but the rights that were at issue in Young were priority and non-dischargeability. And those are procedural rights that were connected to a recovery and would have been lost. And the court did recognize the reason it was limited is because there were some equitable abilities to recover. Nevertheless, those very, very important rights for the United States would have been lost.
How about the tax case?
Beckler was a statute of limitations. There was just one exception. Beckler was also a case that was steeped in equity. It was about the collection due process. Hearings for state court for a particular kind of case where the tax court was going to be levying property. And that really mattered there because that was a context that was very friendly to the lay filer. But in both—
Thank you, counsel.
Haven't, though, General, we been pretty generous in terms of what we call functionally a statute of limitations? I mean, take the Beckler case that you ended on, which was just an appeals deadline. You know, I bet if you put 10 lawyers in a room and said, is an appeals deadline a statute of limitations, they would kind of stare at you funny. You know, what it is, it's a deadline. I mean, a statute of limitations is also a deadline, but we don't typically think of every deadline like an appeals deadline as a statute of limitations. But we've been willing to call it that just because it's a deadline, and if you don't meet the deadline, consequential things matter. Consequential things happen. And so too here. This is a deadline, and if you don't meet the deadline, consequential things happen. Now, in this case, it's the loss of a forum rather than the loss of a claim. But I guess when we're being quite as generous and quite as functional, if you will, as we have been in this area, it doesn't seem to me obvious why we shouldn't say that this isn't functionally a statute of limitations too.
It's very different because although there might be consequences and there might be a right involved, the court in Young said it had to be a substantive right and it defines a subset of claims eligible for certain remedies. And here, when you're talking, it's all about remedy and whether you're going to lose the remedy. And the reason statute of limitations doesn't apply here is because there isn't a harsh consequence. The reason statutes of limitation apply to cases is because, and why there's equitable tolling is because there are very harsh consequences. Somebody's going to lose out completely on their ability to bring a case. That's not true here. They're going to get one forum or another, and maybe they're not going to get their preferred forum, but they're going to get a forum to litigate their case. And that's the biggest thing that separates this from a statute of limitations. And this court has never applied statute of limitations beyond the presumption of equitable tolling beyond statute of limitations, and I think that's one of the reasons why. And if the court was thinking of expanding that at all, it wouldn't be here, it shouldn't be here, where there's a whole distinct tradition of strict enforcement. We cite cases on pages 50 to 51 of our briefs, starting from Babbitt versus Clark in 1880 onward, where this court has strictly enforced the deadline. And there's a reason for that.
Counsel, can I ask you about that context? Because I actually kind of hear you making a slightly different argument. And it is, yes, the court has said that when these rules function as a statute of limitations, the presumption applies. But based on your original analysis or your original statement and what you say in the brief, I almost hear you suggesting that whether or not this functions as a statute of limitations, the presumption shouldn't apply because this is the removal context. And you say in your brief, the federal removal statute provides a comprehensive scheme that governs the allocation of judicial power in this way, that Congress has made this decision. And that seems to me almost to be like a different or separate argument from whether or not this functions as a statute of limitations.
It's just we've set forth a number of arguments for why this doesn't function as a statute of limitations. One of them is history and purpose, and certainly this doesn't function as a statute of limitations because if you look at sort of there not being a historical tradition that there is for statute of limitations, the separate historical tradition here is about strict construction
but do you
and
lose
respect
if we
for
disagree with you on the functioning of the statute? That's what I'm just, lose the presumption point. My only point is I wonder if you have to be right about whether or not this functions as a statute of limitations in order to make your presumption point. That if you lose on that, then we do have to presume that Congress wanted courts to retain their equitable authority, as your friend on the other side says, in this area. And so then we jump to, has that been rebutted? Is there a clear command here? But I kind of hear you suggesting, and I don't know whether it's right or wrong, I just want to put it out there. I kind of hear you suggesting that in the removal context, even if we look at a statute that relates to removal and we say, boy, this kind of functions like a statute of limitations, there are good reasons to believe why we shouldn't presume that nonetheless Congress intended for this to be an area where courts retain their equitable authority.
Yeah, no, I would say the reverse is true.
Okay, tell me.
Yes, if I would say that this whole context of taking, transferring jurisdiction from one sovereign to another counsels for there not to be equitable tolling.
That's what I'm saying.
Yes.
What I'm saying is, regardless, we look at this statute and we might go, oh, yes, this looks like the rights are being transferred. It looks like a statute of limitations. But does that necessarily mean that we should presume that Congress intended for equitable tolling to arise in this situation? And you're saying, regardless of how it functions in this situation, we should not presume that Congress wanted courts to have equitable authority because this is a removal context, and that's like a special thing.
Even if this court thought it was a statute of limitations, in this context, that would butt up against strict construction canons. I also would disagree with my friend at opposing counsel that this test is a clearest command test. There is not a clear statement test here. The test is the test that this court has articulated in Ariano, and that is we're looking at congressional intent. Is there reason to believe that Congress didn't want equitable tolling? And everything here from the text, the structure, the history and the purpose strongly suggests that Congress would not have wanted tolling. We haven't talked a lot today about the exceptions, but when you look at the clear mandatory language, shall file in 30 days, and that's supported by a very comprehensive scheme that has at least 6 exceptions, and those exceptions are interrelated. They're the default deadline of 30 days is repeated multiple times, similar to in Brokamp, and similar to in Ariano, you have these many exceptions that are taking a situation outside of the default rule.
Can I ask a question about state courts? I certainly appreciate and agree with your respect for state courts. Is there some particular reason you want to be in state court in this case?
Yes, because this is a state official, state law claims, and those state law claims have to do with the primary claim in the Attorney General's case is public trust and whether the easement is violating a public trust doctrine. These are state lands and state bottomlands in the Straits of Mackinac. And those are reasons why the Attorney General wants this in state court. Congress has given the parties the choice of forum, and they gave plaintiff the first choice of forum. She was the plaintiff. She chose the state forum. Congress also gives defendants the opportunity to choose a federal forum. And if this had been a case where Enbridge looked at it and said, boy, there's a lot of really, important issues here. We don't think this is state law and we ought to have this in federal court. They should have removed timely. They missed every opportunity to remove timely.
Can you respond to the point that your opposing counsel made about foreign affairs issues or the foreign, you heard that?
Yes. The whole foreign affairs area is not an area where Congress said federal courts have exclusive jurisdiction. So again, we trust state courts to decide big, important federal cases. And even if this turns out to be not a case about state law claims, but somehow, a case about a treaty, we trust the state court to do it with this court as a backdrop.
Thank you.
Justice Thomas, further? Justice Alito?
Did the Attorney General represent the governor in the governor's suit?
The Department of Attorney General represents the governor in the governor's suit, which we do often. And that, sometimes the Attorney General will take one position and somebody in the Department of Attorney General will represent a separate side of an issue.
Why was a separate suit brought? Why didn't you simply move, if there were additional claims, why didn't you simply move to add those claims to the case that was already in state court?
The second suit, the suit by the governor, was brought 14 months after the Attorney General's suit. And although there are some overlapping issues, the biggest distinction with the governor's suit is that it was based on a new circumstance that occurred then, which was that the governor issued a notice and revocation of the easement over state land. And at that point, 14 months had passed. Enbridge had already litigated this case in state court for over a year. And it was a prudent decision to say, the governor's going to file this in state court, assuming that it would be consolidated with the Attorney General's case. And frankly, because there were new parties, new claims.
Assuming that it would be consolidated. Was it ever consolidated?
No, because Enbridge removed the governor's case timely, so it didn't stay in state court very long. And to your to an earlier question, Enbridge could have removed during the 30-day period for the same reasons that they later removed the governor's case. They also could have removed this case when they removed the governor's case, and they could have whether that would have been successful or not would have depended on whether a court thought that they could come under the B3 exception for initial non-removability. And then they had a third potential on October 4th, 2021, when Canada invoked the dispute resolution. But they didn't take any of those. And as the Sixth Circuit held in this case, they missed every opportunity. They were 850 days late. They missed every potential opportunity. And that is now law of the case because Enbridge has not sought to have this court review that part of the Sixth Circuit's decision.
Justice Sotomayor? Justice Kagan? Justice Gorsuch? Ms. Kavanaugh? Justice Jackson? Thank you, counsel.
Thank you.
Rebuttal, Mr. Bursch?
Thank you, Mr. Chief Justice. First, just want to level set the ground here again, and then I'm going to talk about some concessions that we just heard that maybe make this an opinion even shorter than the 10 pages I suggested. To level set, why do we have this presumption? Wong said it's likely to be a realistic assessment of legislative intent as well as a practically useful rule of interpretation. Why is that? Because going all the way back to the beginning of the Republic, Justice Scalia's dissent in McQuiggan says that we've recognized equitable tolling in statute of limitations periods going all the way back to the colonial legislatures. So we don't need an atextual escape hatch. They need to explain why there is a clearest command that Congress intended to take away this court and the lower court's traditional equitable authority. And that clearest command requirement isn't just from Holland. That goes back all the way to Porter. At least in the 1943 or 46, 3 years before 1446B was adopted. So this isn't a new standard that suddenly started getting applied to statutes of limitations in the modern day. It's been the backdrop forever. So that's number one. So number two, how about this presumption? And here's where the first two concessions come in. Justice Alito, you were asking my friend whether estoppel would apply. All lower courts recognize that estoppel and waiver apply in this context. And this court said in Zipes, that was a unanimous Justice White opinion, that those two equitable doctrines and the doctrine of tolling travel together. And so we would expect that if someone could lose their right to remove because they did too much stuff in the trial court, in the state court, or someone could lose their right to resist removal by failing to file a timely motion to remand in the federal court, that there would also be equitable tolling. So that's a huge problem for them. And then second concession, Justice Sotomayor, when you were asking about whether the presumption would apply, is this a statute of limitations? And she was talking about Young. And she admitted that in Young, we were talking about procedural rights, not substantive rights. When you're talking about something like non-dischargeability and priority, those are simply mechanisms to get you to the final judgment. The IRS did not lose its claim to go and get back taxes. It simply had a different burden that it had to satisfy. And the same thing is true here. And so that's why, Justice Kagan, you're completely right that this seems obvious to fit within those types of statutes, because whether you're talking about dischargeability like nutraceutical or in Beckler, this court has not confined the application of the presumption only to those cases where you lose a cause of action. That's happened over and over and over again. Third point I want to make is about this strict construction because of the federalism. I mentioned this briefly, but the two cases that they most rely on, Syngenta and Shamrock Oil, those both strictly construed jurisdiction. And of course, we have to strictly construe federal subject matter jurisdiction when you're talking about state courts' interests. In the first case, it was whether the All Writs Act would provide subject matter jurisdiction to remove. The court said no. Shamrock Oil, it was whether the amount alleged in a counterclaim could count towards the diversity limit, and the court said no. But when you're talking about mere procedural things, there is no strict construction, and there is no construction of this statute that provides that clear rebuttal of the general equitable authority that courts have. Justice Kavanaugh, you're raising exactly the practical points that we're concerned about here. Yes, they brought state court claims, but what we're talking about is an international pipeline that not only impacts the relationship between the United States and Canada, but literally millions of people within and outside Michigan. This is the paradigm case that belongs in federal court. It was a much different kind of federal interest, but one that I think was significant in the Lofton case, which is the 11th Circuit decision that created the equitable tolling doctrine for removal statutes in the 11th Circuit 40 years ago. There, the Navy had been subjected to a garnishment final judgment in a state court that exceeded the federal statutory limit of the waiver of sovereign immunity. And when they removed late, there was no excuse for it. The Navy just blew it. And yet the 11th Circuit said, this is the kind of case that belongs in federal court. We're talking about an invalid judgment entered against a branch of the military. So the fact that the federal government was not diligent and didn't have any obstacles to filing its removal action in time did not stop the court from exercising its equity and putting that case where it belonged, in front of federal judges. You should do that here. So finally, as to the merits of whether equity should apply here, we could go very deep into those. We could have lots of briefing on that. But the Attorney General did not raise that issue in the Sixth Circuit, as we pointed out in our brief. The Sixth Circuit did not decide it, and it's not part of the question presented. You should simply remand and allow that to be worked out. Thank you.
Thank you, counsel. The case is submitted.
As President Trump prepares to deliver the first State of the Union address of his second term, 6 in 10 Americans say the country is in a worse place than a year ago. That's according to a new PBS News NPR Marist poll.
The president will have a chance to try to turn the page tomorrow night, laying out his list of priorities for the year to come. Ahead of that speech, White House correspondent Liz Landers checks in with voters about how they see the direction of the country.
The state of our union is stronger than ever before.
For decades, it's become routine.
The state of our union is strong and getting stronger.
The state of our union is strong.
The state of our union will remain strong.
Presidents walk into the House chamber to project optimism and strength to the American people.
Heading into this speech tomorrow night, just 43% of Americans say the current State of the Union is strong in this latest PBS News NPR Marist poll. That's a 4-point drop from last year. Of course, how you define strength is in the eye of the beholder. So we talked to some of the participants in this poll.
Strong compared to other countries, very much so. Strong compared to what we are or could be, certainly not nearly as strong as we could be.
Others would choose another word entirely.
If I used one word to describe it, I'd probably say terrible. I'm concerned about our democracy. It feels like we are teetering on the edge of losing it all, and that's a pretty scary place to be.
I'm divided because I think the issues are very, very divisive. Trump is extremely polarizing in some aspects for good, because what you see is what you get.
I, Donald John Trump.
Since Mr. Trump re-entered the Oval Office last January, he's pushed policies at a frenetic pace, sending immigration agents and the National Guard to American cities, launching bombs in Iran and missiles on boats in the Caribbean, threatening to take over Greenland, slashing the federal workforce, calling for investigations into his perceived political enemies, all of it testing the limits of presidential power.
A majority of Americans in this latest poll say President Trump's actions so far are changing the country for the worse, and it's affecting them personally. A majority say the policies of his second term are having a negative impact on their lives. Less than a third say it's made life better for them.
We're a year in, and if anything, people's perceptions of what's been going on have deteriorated.
Lee Marengoff is the director of the Marist Institute for Public Opinion. He says views of President Trump's policies are directly tied to people's perceptions of him.
Donald Trump is defining the landscape. You're for him or against him. He's the incumbent, and he's bigger than life in terms of the figure he projects to the American people. So Republicans and Democrats alike divide up along what view people have of him along partisan lines.
2/3 of Republicans feel good, with some pointing to the economy.
I feel like he knows what he's doing because he's a businessman. I feel more comfortable with him at the helm with our economy personally.
More than half of independents disagree.
Nothing's going down in price. Everything's still going up in cost. Most people are struggling these days.
And the overwhelming majority of Democrats say they've personally seen negative effects from the president's actions.
I have done nothing wrong!
Like the immigration crackdown across the country.
ICE agents coming into Minnesota communities and terrorizing people here. I have people I know who have been afraid to leave their houses. I have had family members detained, family members tear gassed.
So tomorrow night, Mr. Trump will likely try for a reset, pushing his policy prescriptions for the weeks and months ahead, like lowering electricity costs and requiring ID to vote in elections, while still continuing his aggressive anti-immigration agenda. The speech is a high-stakes moment for the president.
Donald Trump needs to, in a sense, redefine what his second term is about. He started off with numbers that were much better than they are right now. So the past year, in consultant terms, he's gotten off message.
It's also likely to be his biggest audience of the year, with millions of Americans watching from home. And inside the House chamber, his cabinet tasked with carrying out his agenda, his Republican allies in Congress, Democrats trying to block him, and representatives from the nation's highest court, where many of his executive orders have already been tested and in many cases upheld. But just last week, in one of the most significant blows to his economic agenda so far, the justices struck down tariffs the president had unilaterally imposed on foreign countries.
I'm ashamed of certain members of the court.
After the decision, Trump lashed out, suggesting he doesn't care if they show up tomorrow night.
They're barely invited.
When every co-equal branch of government will be in the same room at a time when Americans' faith in the delicate system of checks and balances is at an all-time low. In the new poll conducted before the latest Supreme Court decision, 2/3 of respondents say the system is not working well. That lack of trust in a core tenet of American democracy has jumped 12 points since Trump's speech to Congress last March, and it has doubled since the month before his inauguration.
I think it's hard to over-exaggerate, frankly, or exaggerate the extent to which the last year has degraded, if not demolished, the basic pillars of constitutional democracy.
Kimberly Whaley is a professor at the University of Baltimore School of Law and author of several books, including How to Read the Constitution and Why. She sees how the branches of government are working together as a deeply troubling moment.
It's not the actual speed limit that slows people down. It's the threat of enforcement or consequence for speeding. It's that ticket that motivates compliance with the speed limit. If the speed limit is the Constitution, where did the tickets come from? Either Congress or the courts. Donald Trump understands there's no enforcement.
I wouldn't mistake what Congress is doing now for some kind of constitutional breakdown.
John Yoo sees it differently. He's a law professor at the University of California at Berkeley and a former Justice Department official in the George W. Bush administration. He says it's no surprise a Republican Congress is going along with the policies of a Republican president.
What he's trying to achieve in terms of reform of the relations of the executive branch with the other branches and presidential power generally is to restore the presidency to the way it was originally understood by the founders.
But Yoo says that voters will hold the ultimate power during November's midterm elections.
Those critics should go and win the elections at the midterms and then place political pressure using Congress's constitutional powers to try to restrain him.
A potential shift that wouldn't be on full display until next year's State of the Union address. For the PBS NewsHour, I'm Liz Landers.
Support journalism you trust. Support PBS News. Donate now, or even better, start a monthly contribution today.
This is Democracy Now!, democracynow.org, The War and Peace Report. I'm Amy Goodman. We turn now from attacks on the right to protest to attacks on press freedom. President Trump is escalating his criticism of the news media, claiming many outlets are engaged in illegal activity. This is part of what he said last week during a speech at the Great Hall of the Department of Justice.
I believe that CNN and MSDNC, who literally write 97.6% bad about me, are political arms of the Democrat Party. And in my opinion, they're really corrupt and they're illegal. What they do is illegal. These networks and these newspapers are really no different than a highly paid political operative. And it has to stop. It has to be illegal. It's influencing judges, and it's really changing law, and it just cannot be legal. I don't believe it's legal.
President Trump's comments come amidst a right-wing push to overturn protections for the press to investigate public figures, a right guaranteed by the landmark 1964 Supreme Court decision, New York Times versus Sullivan. We're joined now by David Enrich. He's New York Times Business Investigations editor. His new book is titled Murder the Truth, Fear, the First Amendment, and a Secret Campaign to Protect the Powerful. If you can start off, it's great to have you with us, David, by talking about what this Supreme Court decision, this landmark decision in the 1960s, Sullivan, was all about.
Well, it was brought on behalf of supporters of Martin Luther King, and it basically detailed this litany of abuses by Southern officials. The gist of it was completely true. Southern officials were trying to preserve white supremacy. Some of the facts were either wrong or exaggerated. And a powerful Southern official named L.B. Sullivan sued the New York Times and won at trial. And the goal, basically, of Sullivan and his pals was that by filing lawsuits that seized on tiny little inaccuracies, you could punish the media for covering the civil rights movement. And so this went up to the Supreme Court, and the Supreme Court ruled in a unanimous decision in 1964 that in order to preserve free speech and allow people to write and criticize and investigate powerful people and institutions, the media and the public needed breathing room so that if they got a fact wrong by mistake or made an honest error, they would not be sued into oblivion. And so that Supreme Court ruling has really set the stage for decades of investigative journalism and for normal people, non-journalists as well, to speak up and kind of reveal abuses and criticize people who hold positions of power, both at the national level or at a community level as well.
And what does this mean for the First Amendment?
I mean, it means that the First Amendment gives everyone the right to speak and to interrogate powerful people. And you do not need to worry about, there should not be a legal cloud hanging over your head when you criticize or investigate someone powerful. And you do not need to worry that an innocent mistake is going to bankrupt you because of litigation.
So let's go back to 2016. Donald Trump vowing to make it easier to sue news organizations.
I'm going to open up our libel laws so when they write purposely negative and horrible and false articles, we can sue them and win lots of money. We're going to open up those libel laws so that when the New York Times writes a hit piece, which is a total disgrace, or when the Washington Post, which is there for other reasons, writes a hit piece, we can sue them and win money.
So that was before Donald Trump became president the first time around. Talk about the significance of what he's saying, and the overall campaign is in your subtitle, The Secret Campaign to Protect the Powerful.
Well, when Donald Trump made those remarks in 2016, it kind of acted as the firing of a starter's pistol in a race. And it sent a signal to the entire kind of conservative movement, and in particular, the conservative legal movement, that a race was on to try to dismantle some of the longstanding First Amendment protections for the media and